Welcome to the It's Been Said podcast. I'm your host, SAI Executive Director Lisa Ramey. Today's episode is a special edition of the It's Been Said podcast. Matt Carver, Legal Services Director, will discuss his perspective on current legal topics relevant to district and school administrators. He'll offer his insights on this subject matter periodically over the coming months. Let's hear from Matt.
This is Matt Carver, and this is SAI's Legal Vortex. So today we're going to go over one of the more common issues that I get calls about throughout the year, and it really is for all different grade levels too, for students throughout our school systems in Iowa, and it relates to decision making, and particularly, of course, education decision making. So who's able to make those decisions? How do schools go about balancing situations where, for instance, we'll talk about when parents have joint legal custody and how decisions are made, and then also a variety of other situations that regularly come up. So first, I'll talk about a common one, and that relates to scenarios in which parents have joint legal custody. The courts in Iowa are inclined these days to provide that joint decision making to both parents, regardless of whether or not the student or students are spending more time with one particular parent. So even in those situations where one parent might have primary physical care, even in those scenarios, often the courts now are providing joint legal custody to both parents where they're both involved in decision making. When you have a situation where parents both have that joint legal custody and maybe they disagree on something, then it's a matter of doing your best to determine what's really in the best interest of the student. So if they're not agreeing with each other, you have two parents, they're disagreeing about a particular educational decision, then you're left in a position to do your best to you certainly may be the tie-breaking vote in those situations. The school has that authority to be the tiebreaker and say, well, based off of all the information we have and we've been able to gather, that it appears that a particular decision is in the best interest of the student, and so the school is going to go along with that. Now, at times it might be so confrontational between parents where you just decide, you know what, we're going to err on the side of the status quo. We're not going to really pick one or the other. It might appear that that's sort of siding with one particular parent, but we're just going to go along with the status quo here and then encourage the parents to go back and if they need to go through the court system to help to make a particular decision. If there's disagreement, they could do that as well. Now, beyond those situations, again, that common one with joint legal custody, another one that I'll get often is situations where you have step parents, you have significant others, you maybe have grandparents who are very involved in the lives of the students. And that's great. I think we'd all agree that it's a good thing if we have more adults who care about the well-being of the students in our schools. They want to be involved, they want to be helpful. That's a wonderful thing. But having said that, even that individual who is there, they might be there more often than particular parents there, or particular guardians there. They might be showing up to school more. They might be more involved in that student's life. Having said that, just due to the fact that they might be a step parent or a grandparent does not give them decision-making authority. And so, in order to have that authority, they either need to be appointed as a guardian by a court here in Iowa, which happens on occasion, or you'd need to have a parent who or a guardian who has that authority, who has signed a power of an attorney for that individual. I'd say it need to be notarized power of attorney. They're granting them some limited authority to make educational decisions, for instance. Well, then if they have that and they're able to prove that, they show that to you, then that that would provide them the ability to make some decisions on behalf of the student, because really they're doing that as a result of authority that's been granted to them by one of the individuals who already has legal decision making authority. So look for that, potentially that power of attorney, or again that appointment as a guardian. Now, I've gotten, I can't tell you how many times over the years where I've gotten calls and a parent has written on a piece of paper, it might be a handwritten note, I give guardianship to so and so. Well, that doesn't cut it. And that's not enough to pass legal guardianship. It's probably no surprise to you, but I trust many of you listening to this today have had situations like that where someone shows up, they have this note. Oh, yeah, yeah, it is indeed that person. It is indeed that parent. They've signed the note, but they're unable to just pass guardianship by writing a letter or writing a note in Iowa to another individual. So keep that in mind. And with all of this, of course, it makes some sense to talk to those staff members, often in your offices, or it might be the teachers of particular students. If you know that there's some disagreement there, make sure that they're aware who has these types of educational decision-making abilities with these students, just so they understand they're not manipulated potentially by someone who shows up in the office and shows them a note or is friendly with them and is very active in the child's life. Well, again, that's nice, but it doesn't give them the authority to make decisions. So that's something to keep in mind when you have, again, situations with step parents, grandparents, significant others. Those are really the most common groups of individuals who are involved that I've seen over the years, where there's some question whether or not they have authority to make decisions. Another group that'll come up, of course, is foster parents. Now, foster parents, at times, they're often given some decision-making authority by the state, but you'd want to see whatever paperwork they have, particularly relating to an individual student. And don't assume that one foster parent necessarily has the same decision-making authority as another foster parent. So at times, the state will grant them additional authority to make decisions. It's more common, I would say, that they're able to make some very routine types of decisions as far as, picking the student up from school to, of course, take him to medical appointments, or maybe some very minor decisions there at school. It wouldn't necessarily be as common that they're able to make very large, significant decisions relating to a child, such as whether or not that child's going to receive special education services. So while it might be appropriate, they might go to IEP meetings, they might be an individual who's very helpful to provide information to the staff there. But I would say it wouldn't be quite as common that that individual would have so much authority that they'd make decisions of, well, I'm going to withdraw a student from the IEP or from receiving services as a student with disabilities. So that's something to keep in mind as well. And again, I'd share that with some of your office staff. And then another one that comes up relates to and I'll get a lot of calls on this from high school principals or assistant principals, deans of students, relates to 18-year-old students. Well, what about 18-year-old students? When students turn 18 years old, they do indeed have decision-making authority. And so that can cause a lot of friction within families, but that's something that those families are going to have to work through together just amongst themselves. But the bottom line is, and I've had, again, many calls, many emails where that 18-year-old all of a sudden wants to make some other decision or makes another decision, and the parents disagree. The parents might be contacting the high school principal or someone saying, well, no, we don't want them to do this. Well, the fact of the matter is that 18-year-old student does have that authority generally to make those decisions for themselves. And so that might cause, again, some issues within their family, but That's sort of the bottom line. And with that, when you have those types of situations, and I'll frequently talk to administrators about there's no harm in sharing that, well, you know what, I checked with the school law attorney and he or she said that this is what we're required to do by law. And so just that gives you a little bit of cover, I'd say, in those situations, and it's a fair and accurate statement, whether that's based off of you listening to this podcast or you contacting me or an attorney for your school district directly and asking them questions. But sometimes that helps somewhat with that interaction with those parents who at times are very frustrated that now their child's doing something with which they disagree, and now that parent or a guardian may be upset at you about that. So keep that in mind. I think it's something it's a wise thing to do, to just share where you got this information and why you need to allow that student to make the decision now that they're 18. Now, with that, there are some situations where those 18-year-old students have such severe cognitive disabilities, or they may have some other type of mental disability where a court has still decided, even though they're 18, has appointed someone to be their guardian. And so that will, of course, happen on occasion due to the severity of particular disabilities. And so if that's coming up, and it might be something, even talk to the parents about that ahead of time. You might say, well, we know that Katie's, about to turn 18 years old. Do you have anything yet? Or are you working towards getting a guardianship for when Katie's 18 years old, so that you have authority to continue to make those decisions? So that would be something else to consider. Now, having shared all this, while many of these different individuals I've talked about may not be decision makers for educational decisions, for significant educational decisions, the school staff may still listen to them and take input if it's helpful to the staff to make a decision. And so while that step parent may not have decision making authority, it's okay for your staff to listen to that step parent, listen to things that they share with you about the student, or perhaps that parent is having that step parent or that significant other go with them to a conference, go to an IEP meeting, and they're there with them. It's okay to listen to those adults and perhaps even ask questions of them. Well, what are you observing at home? And just gathering some of that information. So keep that in mind as well. That distinction between decision making and information that may be helpful for your educators to make those decisions or to better educate a student. Another thing that I would say is, and it really goes along these lines, is on issues of attendance. Then on issues of attendance, you may decide, or your staff may decide that, well, we're going to accept a call from this individual for the student. They're missing school today. And that helps to verify that this is indeed, yep, they're picking them up, they're going to a doctor's appointment or whatever. And in my opinion, you may base some decisions off of input from that grandparent, from someone else who's been, maybe is listed as a contact or someone to pick up the students by one of the parents. That, in my opinion, you certainly may use information from those individuals to help to give credibility to whether or not a particular absence should be excused or not excused. Now, outside of power of attorney or guardianship, another way or another form that may be used for an adult to make decisions is the homeless student caregiver authorization form. So this is something that's provided under McKinney-Vento, under federal law for homeless students, and I'll get calls at times relating to situations where the student is living. They're pretty clearly a homeless student. There's no legal guardian there with them. The school's unable to be in contact with any of the guardians, with parents or decision makers. And in those situations, if the student's a minor, then you may use a form, and SAI members may find this on our website, on the SAI website, and it's a caregiver authorization form. So that's something, again, if there's an adult there, they're helping to watch the student. They haven't, as of yet, gotten guardianship for the court. Now, I will say for younger students who aren't, close to turning 18, it does make sense that if the parents just aren't around, you're unable to find them or get in touch with them, then that individual probably should be pursuing guardianship. But that is something in the interim that may also be used is the caregiver authorization form for homeless students. So again, just check that out. You can get that on our website. I got that approved by the Department of Education a number of years back, probably, I don't know, maybe 7 or 8 years ago, where they reviewed the form that I developed based off of information from that I obtained from the federal government. And so you're good to go to use that form as well in the interim for those students who are homeless. With that, I hope that this has been helpful. Again, I know these are very common issues that come up. Again, at the end of the day, it's about making decisions in the best interest of those students. The courts, again, are going to make decisions in the best interest of the child. So just keep that in mind. And as always, if you have something that comes up and you have additional questions, don't hesitate to give me a call. 515-267-1115. I appreciate all of you and what you do for Iowa students, and have a great day.